All right, folks, so we're back. So, hey, listen, it's live. That's what happens when it's
live.
Yeah, live. So, in fact, I got to try to get it back on here. So, we were talking last about kind of to wrap up on the conversation we're having, but you do have access to help people,
Absolutely.
Not just in South Florida.
Absolutely, and there's a lot of people that live in South Florida, but they may have a vacation home or a second home in Orlando, St. Augustine, Pensacola,
Right.
wherever, in Fort Myers, and they may come across a situation where they might not be able to sustain both properties, and obviously they're going to pay the house they live in, and that second property is going to go by the wayside. But we have a way to defend those properties as well and work through the different options that you have when you find yourself in that situation. What I don't want people out there to think is that it's just going to go away magically, or that the bank is never going to come after them because it's been more than 5 years since they stopped making payments on the loan. The law has changed in the state of Florida, and they absolutely can come after them for that purpose, under certain restrictions, but they can definitely come after them if it's even beyond the 5-year period. So I just want to invite anyone that's out there that either is in a situation where you're in a potential foreclosure, or you're in a foreclosure, know anyone that's in a foreclosure, or even if you haven't gotten to a foreclosure yet, but you're past due with the bank 2 or 3 months, and you're trying to figure out what you can do. One of the things you can do is start a loan modification right away, and then under the CFPB guidelines, the bank cannot proceed with a foreclosure until they give you a yes or a no on your loan modification.
That's called dual tracking, right?
Right.
They're not. Didn't that result as the settlement that the feds had with the large banks back in the day?
Yeah.
That was part of it. Is that hey, listen, if you're attempting to work something out, you can't have a sword over their head at the same time. You're supposed to give them the ability to go ahead and try to work it out.
Exactly. It was basically like a 3-month cool down period, prior to filing any kind of foreclosure. And that little window of time from the time you get your notice of default to the time that they file foreclosure is usually about 3 to 4 months, and that's the ideal time to put together the loan modification document and submit it to the bank, because they can't proceed with a foreclosure until they give you that notification. That is part of the dual tracking restrictions that were placed on servicers and lenders as a result of the 345-page order, multi-district order that was issued way back when, which prevented them from doing all that.
How can people reach you? I want to give your information out at least once or 2 or 3 times during the show so they can reach you. Best
way to reach me is either by email or by telephone. Our main office is in Miramar, where we serve clients in all over the state of Florida. Like I said, our main office, the number is 954-437-9066. 954-437-9066. We take calls pretty much all day during regular business hours. We'll give you an appointment, a face-to-face appointment. I don't believe in these, Skype appointments or telephone appointments. You don't call a mechanic and say, fix my car over the phone. You actually have to take the car over to the mechanic to get fixed. That's the philosophy that I take with foreclosure cases. If this is important enough to you, you bring it to me. I'll try my best to fix it. And I do face-to-face. The other way you can get a hold of me is via email. Info at arcialawfirm.com. ARCIA lawfirm.com.
So, switching gears a little bit.
Right.
Okay. Somebody wants to purchase real estate, investment properties. And I'm asked this question a lot. Should they buy it in their personal name, or should they incorporate, maybe form an LLC for the purpose of buying investment property?
Yeah, I actually go a step beyond that.
Okay.
And if your goal is to acquire investment properties, I firmly recommend the client not to put it in certainly not in your name.
Okay.
But sometimes not even in a corporate name. I recommend to people to put it in what's called a family trust.
A family trust, okay.
And with a family trust, like any other trust, it's got a trustee where it's managed by someone else. So the property is technically not in your name, not in a company that you control. It's on a completely separate entity which will prevent any creditor that may have a judgment against you from coming after you or taking away that property, because now that property belongs to your entire family. It's no longer just your property. And it's a something that we've done for a lot of our clients,
Okay.
and they're very thankful that we've done that, because it's a great management tool to manage your assets, and fairly inexpensive. I mean, you can set up the easy route, of course, is setting up a corporation. But what if you're the only officer of that corporation? What if you're paying yourself right out of that corporation as money comes in? What if you're not observing corporate formalities? Well, what happens is when you go to court or someone sues you, they can come after you personally and the corporation, because they say it's one and the same. Right, something called the alter ego doctrine. So you're basically just setting up an alter ego of yourself under the name of a corporation.
So the corporate veil.
Yeah, the corporate veil will be pierced
Yeah.
if the other side can demonstrate that you're just using that corporation to prevent other creditors from getting to you, and you're not really observing corporate formalities like having other directors, like doing the annual meeting, like doing all the things that you need to do as a corporation to demonstrate to the outside world that you're operating as a corporation.
It's a great point. And by the way, folks, take this opportunity to type in your questions. Again, we want to get to as many of them as possible. Don't be shy. No question is off limits. It's something I don't even know we can tackle today, but you brought up an interesting point, is more and more real estate agents are incorporating for the purposes of their businesses. So they're operating as an LLC or a PA. And part of it is tax advantages. The other part of it is, protection from potential liabilities. And I just wonder if that's another area that we should one day have a conversation about, is how protected are the agents themselves if essentially it's a one-man or one-woman corporation and they're paying themselves in all those scenarios there.
Right, yeah, I mean, that's something that I deal with from time to time, not necessarily with brokers, but also just entrepreneurs, business people that want to set up, and other professionals like accountants and attorneys that want to set up a separate PA.
Right.
But just bear in mind, Tony, that because of the fact that we're professionals, and we had to take certification exams, and we are held to a higher standard. Brokers are held to a higher standard because it's expected that you know more than just a regular layperson that may not know about a real estate transaction.
Absolutely.
So when you're looking at that situation, that you're held to a higher standard, then you need to be very cautious about how you protect yourself from potential exposure. We talked about the issues that we may have if FERPTA guidelines are not properly followed in those types of transactions, where you may have a buyer that's hit with the IRS for a FERPTA claim, and the broker didn't properly advise that buyer, and then the buyer, guess what's going to happen? The buyer's going to come after everyone that they may have a claim against.
So let's do this. You threw out a term, FERPTA, and to the average person listening, they might think, "What do you say about my mama?" So we're going to come back to that in a second, because that is another Pandora's box of potential issues there. Can we agree on something? We agree on more than just a few things, but I've always been a believer that just because you can doesn't mean you should.
Right.
Okay, and licensed real estate professionals, you get a Florida license, you can do all number of types of real estate. You can do commercial, you can do short sales, you can do all. It doesn't mean that they should. Well, the same thing applies in your industry as well.
Absolutely.
Right.
Yeah.
I mean, if I need real estate help, why am I calling? I don't know, a divorce attorney? Should I call someone that specializes in real estate as well? And I think that's the other thing too, is sometimes we look at titles and we think, well, they're an attorney, they must know what they're talking about, or they're a real estate agent, they must know about these, but there's specialization within our industries.
Right, and I tell people all the time, and I give them this analogy. I mean, we call dentists doctors too, right?
Oh, thank you, sir.
Yeah,
absolutely.
We call dentists doctors too, but you wouldn't go to a dentist to do open heart surgery. I mean, you go to specialists that specialize in that particular area to give you the very best service and to also give you the best outcome for whatever you need. The same thing with real estate, the same thing with attorneys. There's a lot of attorneys out there that say they're a real estate attorney, but you need to ask them, how many years have you been doing this?
Right.
How many clients do you have that specifically require real estate assistance? Go on their website, check it out. I mean, I can't tell you how many clients come to me years after the foreclosure case starts,
Yeah.
and they realize their attorney has no clue how to defend a foreclosure case. And when I receive it, I see that they have no clue how to defend a foreclosure case. So you got to do your due diligence. Anyone that's out there looking, especially whether you're a broker, whether you're a consumer, make sure that you're advising people that are in a real estate, in a foreclosure situation, that they need to look for a foreclosure defense or real estate law firm. I've been doing this for 23 years this year. It seems just like yesterday, but I've represented both lenders as well as consumers. Most of the time I've represented consumers, but I've been doing this all day long for the last 23 years. I mean, I had a conversation with a client coming over here, and the client's like, well, we have a major hearing tomorrow. The client wants to make sure that I'm putting out there the right arguments. I like clients like that, you know? But the bottom line is the client says, I feel so comfortable that you know our case so well.
Yeah.
I said, listen, with all due respect, I appreciate you as a client, but it's not your case that I know really well. These are the same arguments that we bring up in a lot of these cases.
Yeah.
So, and I know them from the top of my head because this is what I do. No different than a cardiovascular surgeon knows exactly what valves to operate on as opposed to a dentist.
Yeah, it's not your first rodeo.
Right.
Right. So just to make sure that, because we have a couple of questions I want to address here, they're coming in from Facebook. Again, send in your questions. But you would agree that if maybe not necessarily the family trust initially, but definitely don't buy investment properties in their personal name. Okay, but so option number one is form an LLC and buy an LLC, and then potentially explore the option of, so you would recommend the family trust scenario even if they only have one property?
Well, I mean, if you have multiple properties and multiple assets,
Mm-hmm.
I mean, whether you're an investor or just someone that has multiple assets, you need to be talking to a probate and trust attorney.
Okay.
I mean, and I can't tell you how many people I meet with it. They don't have a will. They have tons of assets.
Yeah.
And they're completely exposed if they get hit with any kind of judgment or any kind of lawsuit. You need to protect yourself, guys, because right now, I mean, as good as you may feel you are, there's someone right on your heels waiting for you to screw up, and they're going to come after you.
Yeah.
And that's just the way it is, unfortunately. That's a society that we live in. You have people who sometimes are looking for their professionals to kind of screw up even a little bit, and they're coming after them because we're a litigious society. That's just the way it is. And we have to protect ourselves and our families against that.
One of the questions asked here is as far as the lien search and everything. So why is that so important? I mean, again, I know why it is, you know why, but the typical maybe lay person out there, what exactly is the lien search? What are they looking for? And what's the real reason behind all that?
You're looking for anything, what's called any encumbrance on the property, which will impact your ownership rights to that property.
Okay.
So if you're a buyer and you're buying a property, you want to make sure you get clean, marketable title.
Okay.
So if you want to sell that property in the future, you want to be able to transfer a title to that property without any issues. If you buy a property and it has tax liens on it, it has municipal liens on it, it may have county liens on it, it may have a contractor's lien on it. If you buy a property and it has all those issues, you may have that person may have a final judgment from a creditor that they attach to that property. Right. If you buy that property without taking care of those liens, and that's what a title company does, they identify those liens and they make sure that before that property is transferred or sold, all those liens are taken care of. I see so many times that there's a transfer of title by a quitclaim deed or any one of these concocted self-help deeds that are done, but you don't realize that you're buying all the liens that are associated with that property. Yeah, you're the owner now. You're also the owner of all those other responsibility associated with that property. So it's so important, guys, to make sure that you're working with a solid title company that's going to investigate and look into any lien that's on that property, especially municipal liens, because those are now required under a new contract. They have to disclose that as well.
And people get frustrated. I understand, the purchase, thank you. There's some good questions here. I know the purchase of a property is so emotional, and it's complicated. I mean, I don't know if it needs to be this complicated or because we are in a society where they'll sue you as a litigious society. it's there's layers upon layers and upon layers. So it's time consuming. It's a process. It can be frustrating, but it is for the protection of the buyer.
Absolutely,
for that to happen.
absolutely.
So let me ask you something. I'm a professional buyer. I'm a professional investor. I don't care about these liens. I know I can get rid of them. Can I close even with all those liens on it?
Yeah, you can close. I mean, you can buy a property. If you're working with a decent title company, they're probably not going to go forward with the transaction because they're going to tell you, hey, you can close with whomever you want, but I'm not going to close it because I can't give you title insurance.
Yeah.
That's what you get from a title insurance company. You get the assurance that if something happens to that property, you can come back to them and say, hey, you told me there was nothing wrong with this property. It was free and clear. And now there's something wrong, so now you've got to pay.
Yeah.
Right? And the title company will go back to their underwriter. Their underwriter cuts you a check to clear out those liens. I've got tons of litigation on those issues.
Yeah.
And that happens all the time.
And then typically, if it involves a loan, the lender's not going to be okay with that. These are normally cash professional buyers that say, hey, I'll take it. In some cases, the title company, at the end, the title company can't tell you not to buy it. You're an adult, but they can have you sign a hold harmless agreement, basically saying you're taking this responsibility upon yourself, right?
Right. There's certain liens that can't be cleared out. I mean, there may be some tax liens, there may be some judgment liens that can't be cleared out. And as a buyer, you have the option of saying, I'll close anyway. I'll take it. I'll just take the property subject to those liens. You know, one thing that really bothers me is a lot of investors right now are thinking they're getting a great deal buying these foreclosed properties when there's association liens involved. When there's association foreclosures. You've seen those before, right? So the people are buying this $100,000, $200,000 property for $16,000, and they're saying, wow, I got a great deal, right? They don't realize that there's a first mortgage that they're going to have to contend with. And what happens is ultimately you're going to be out that $16,000, $17,000, $20,000 to pay off the association lien. And you're not going to have the right to keep that property or sell that property because you got to pay off the first mortgage. And then that happens all the time. The other thing I want to talk to the viewers today about, Tony, is something called surplus funds. I mean, I like the word surplus because that means there's extra.
Right.
Like when you get extra helpings, at dinner or whatever. Well, surplus is what happens when you have a foreclosure sale and there's extra money left over in the court that goes back to the original owner. A lot of people don't realize that, and there's literally millions of dollars sitting at the clerk of the court in Broward, Dade, Palm Beach, all the counties in the state of Florida, of foreclosure sales that have happened, and people have paid more than what's owed to the bank.
Wait, and they can't find these folks to give them their money back?
Well, a lot of these people are no longer at the property that was foreclosed. So the only last known address they have of that person is the property that was foreclosed. So when they send notification to them that we have some money for you, it's torn up because it's in the name of a previous owner.
Oh, man.
Right? So now you got to understand that you only have 60 days. If you're a second mortgage holder or any lien holder on those properties, after the foreclosure sale, you have 60 days to make that claim. After that, the last known property owner can make a claim. I just did that in a case involving Bank of America. Bank of America waived its right to come after the surplus that my client got foreclosed on after not paying his house for 5 years. And Bank of America, who had a first mortgage on that property, because this was a association foreclosure.
Right.
So Bank of America had a first mortgage on the property. They forgot to file their claim for the surplus. $129,000 was sitting in the account. I went in as the last owner of the property, even though my client got foreclosed out, and the court had to pay me that money.
What I'm confused is that in other words, the property was not underwater when it was foreclosed on.
Right. It wasn't underwater, or it was an association foreclosure, which means that there was extra money that was paid because people are thinking I'm buying this property, when in reality all they're buying is the debt. when they're buying a property for in an association foreclosure for like $17,000, they may say, "Oh, I got a great deal. I'll pay $25,000."
No, because there's still a mortgage on that property, and the bank's going to foreclose against the association.
Right, and that's what I tell people. If you're going to be investing in properties, especially in foreclosure auctions, you need to be represented by counsel. I have clients that's all they do is they say, "Omar, I want you to take a look at this property, run a title search on it, tell me what my exposure is on this property because we're thinking about bidding on it."
Oh, you can do that?
Absolutely.
Okay.
And I consult with clients all the time to give, especially investors who are looking to buy multiple properties at foreclosure auctions. And obviously when you consult with an attorney, you get an opinion letter from an attorney, now you're clear. Now if you've got partners or anything like that, you're investing $100,000 into a property.
I love it.
Now you're going in with your eyes open as opposed to jumping into the pool head first, not knowing what's underwater.
Okay, got some great questions here.
All right, let's tackle them.
All right, so one I would like to attempt to answer first because you know what, when I grow up, I want to be just like you. That's one of the things I strive for. And the question was asked: vacation property, if they own vacation property, should be in an LLC. My first response is it better be in something other than your personal name, because somebody slips and falls at that vacation home or whatever, and they decide to sue someone. Who are they going to sue? You personally, right?
Absolutely. If you own that property and if it's in your name, if there's no insurance on the property and they slip and fall, then they're coming after you. Or your insurance lapses. Yeah. Sometimes you have a vacation home, you don't even realize they send the insurance notification that it lapses to your vacation home, and you don't even realize you don't have any insurance. Someone falls, slips, and dies in that vacation home, they're coming after you.
Got it. Another great question here is what happens if the property has open permits and the seller doesn't want to close those out? What options does the buyer have?
Well, under the new contract, the buyer has a right to ask, like I said during the last show, for all the information regarding those permits, right? And at the end of the transaction, if the seller cannot deliver clear, marketable title, the buyer can back out of that deal.
What if they don't want to back out? That's the thing is, I get that, but what they're truly motivated, they want to buy the home, but nobody can really force that seller to do that, right? Or would that be considered they're in default of the contract because they're not doing any effort to achieve clear marketable title? So what can the buyer do? Did they force their hand at all?
The seller has to try to get clear marketable title, but if the seller is unable to clear out those permits or get finals on those permits, then the buyer can agree to waive the marketable title provision and close anyway. It's just like what I told you with respect to the liens.
Right.
The buyer has a choice of not clearing out those liens and closing anyway. It's risky. It's very risky. I would never buy a property. I would never recommend it to a client to buy a property knowing that there's open permits on that property, because you never know what kind of Pandora's box is associated with that open permit. That's why the new contract requires that the seller provides you everything, not only in his possession, but in the possession of anyone that had to do with those open permits. GC, the general contractor, the architect, the engineer, anyone that has any association with that property.
And it's all relative too. I mean, an open permit on a fence or something small versus an open permit on a room addition, there's different degrees of exposure for that buyer. So it shouldn't affect the financing aspect, or if they're financing, might the bank not go forward with the loan if they're open permits? That's not the same as a lien scenario. It's not as a big an issue with a bank.
Yeah, I mean, if you waive the open permit and you make yourself responsible for that, then I don't think there's going to be any issue with title or with the bank in getting that financing.
And you still have title insurance, so you're still covered, but irrespective of
exclusion. They'll put it as a title exclusion from your title policy. So if for some reason you can't clear out that permit in the future, you can't come back to that title company and say, hey, you didn't tell me anything about that permit that was open. But keep in mind something else, Tony, that some of these open permits, and I've seen this happen too, is that you have an open permit for, say, a fence, but they come back for that final inspection, and they realize that you have a unpermitted deck that you've made in the back of your house, because now they're on your property, and now the inspector can look at anything that's on your property. And as they walk through your deck, they realize that you have unpermitted, unlicensed electrical connections that are put outside your house. and there's unlicensed plumbing. So now you've built an extra little room in the back of your house that has no licensing whatsoever or permitting. So now all of a sudden, the little permit that had to do with the fence just opened up that Pandora's box.
Listen, that never happens in South Florida. So
No.
I mean, I would appreciate it if you kept your comments to something that's actually realistic, because there are entire cities or municipalities out there that are known for anything like this. Do not mention any names. We don't want to offend anybody.
No one in South Florida. Unpermitted construction.
Absolutely, that never happens here. But that's a good point you bring up, just in case one of those weird scenarios happens. So another question to ask here. So last week we talked about how there's a new sheriff in town, there's a new purchase agreement and everything else. And have you seen anybody freaking out about that yet?
I don't think I've seen anyone freaking out about it, but I've talked to quite a few people. I'm doing a seminar on it next week.
Okay.
I'm doing a seminar on it next following week. But what I have spoken to is plenty of brokers that are completely unaware of the fact there's a new contract around.
The broker?
Absolutely unaware. And a bunch of agents that are unaware of the fact that there's a new contract, because I know they're unaware because they're telling me, how long do we have to get the loan commitment? And I said, there's no more requirement for a loan commitment. Does it have to be in writing? No, it doesn't have to be in writing anymore. It could be a verbal loan approval. That's all they're looking for. As long as the buyer notifies the seller in writing that they have been approved, they're good to go.
So, that's just scary. That's just scary, because being in the business as a broker that prides himself on, staying up to date on all this far into the process, that there are agents out there got exposed and there are companies out there that exposed, and at the end the consumer is exposed as well.
Yes.
So listen, trust but verify, folks. Reagan said it all right there. Make sure that the person you're hiring to represent you either on the sales or buying end knows what they're doing. And look, I want to give a shameless plug. Besides my health, I do this show because we do want to let people know that there is a real estate company out there that prides itself on its service, on its results, on its culture, and that's Xtreme Realty Team. If myself or anybody on my team can be of service to you, please don't hesitate to call 954-530-0211, 954-530-0211. How can I reach you again, Omar? And I'm going to go ahead and pull up another question here for you.
The best way to reach me is going to be by phone, 954-437-9066. Call us. We can make an appointment. I like to meet with my clients face-to-face regarding any of these issues. Like I said before, no case is too small, no case is too big. We'll take a look at it. I'm all about making sure that the people who are bringing business to me are properly served, and they feel like there's a genuine interest in what they're getting back.
Yeah.
One of the reasons that I partnered up with Xtreme is because of the teaching component.
Right.
I like having educated clients. I like working with educated brokers and agents, because it's a lot easier to kind of walk through the process than if you're teaching them as you go along. That's why we do the seminars that we do. We want to make sure that people are up to speed, because ultimately those are the ones that are on the front lines dealing with consumers, and we want to make sure that consumers out there are absolutely given the latest and the best information that's available.
It's caveat emptor. Buyer beware. You have to protect the consumer. That's what it really comes down to. But the consumer has to protect themselves as well. That make sure that you're asking the right questions of the people involved. Another great question here for you. It says, what happens if an association does not include special assessments on an estoppel letter and the buyer finds out after closing?
Well, remember, there's always 2 layers of association, sometimes 3, because there's different association. There's a master, and then there's a specific association. So sometimes, that responsibility falls on the title company. That's one of the things that New World is very good at. They will make sure that there's no outstanding association liens out there. They'll go to the master, they'll go to the specific association and say, I need an estoppel letter from each of you. Now, if that estoppel letter is missing information, that estoppel letter basically binds the association.
Okay.
So if the association in the estoppel letter did not include certain amounts that were owed for that specific association, they can't later come back and say, oh, by the way, they also owe this amount. And the reason why they can't do that is because literally the association debt runs with the property,
Right.
not the person. Once a person moves out, all they can do is come after that property itself.
Right.
I mean, I've had association attorneys even and association managers say, "Oh no, we'll just come after your client if they don't pay this debt." And I said, "You can't come after my
Well,
client.
you
What
have
are
to
you
eat it. You issued the letter. You had your opportunity. That's
Exactly, and it's you can. It's not a personal debt. It runs with the property itself.
So I'm going to come back to FERPTA in a second, but just recently, new legislation has been passed to deal with the issue of these runaway fees charged by association on estoppels. And no time today to tackle that, but let's talk about that next week. Because I think it's important because, as a real estate professional, it drives us nuts to see what some of these associations are doing and how much they're charging. And it's become a profit center for them.
Right.
Right. And so now at least there's going to be some level of protection and restraint in that area. But back to FERPTA. What is FERPTA and why should a consumer and or a real estate agent be at least familiar enough to know what signs to look for?
Right. The FERPTA provisions, it's found in every one of your real estate contracts. It deals with foreign investors, basically foreign sellers that are selling property here in the States that are going to be taxed on it. I mean, they're gaining a profit from the sale of a property here in the States, so they're going to be responsible for a tax. Now, the way that the IRS has required that this tax be collected is through the buyer itself. The buyer can either escrow the 15%, generally it's a 15% tax on the net
Proceeds,
on the proceeds of the sale, or they can just send it to the IRS. And there's a lot of different exceptions to FERPTA, which we're definitely not going to tackle today. But the one thing that I would point out to people out there is one big, not a change, but just kind of like a reiteration in the new contract is it reminds you that if you have any issues regarding FERPTA, any issues regarding whether or not that tax needs to be collected, escrowed, reduced, waived, please talk to a tax professional or an attorney to make sure you have an opinion letter that allows you to escrow that amount or basically waive that amount. Obviously, if the seller signs a non-foreign status affidavit, then you're clear because that person is not a foreign. That's what you usually sign in all these transactions. At closing, right?
But how about moving it up? Okay, so when you say foreign, okay, because listen, I was blessed that my parents moved from Cuba to here, but I wasn't born here. In fact, we share that ancestry.
Right.
Okay, so it doesn't mean that you weren't born in this country. It has to do with your status, right?
Right.
Okay, so I just want to make sure that they're hearing what we're saying.
Right.
Okay, so who is potentially, define who that foreign person is? Is that someone that doesn't have a social security or is not a legal resident? Because I thought some of these questions that come up.
Right, and it has to do with someone that doesn't have residence in the United States and doesn't have a social security number.
Okay.
So you're talking about foreign nationals
Right.
that purchase property in the States, probably purchased it in cash.
Got it.
And it's just sitting there and now they want to sell it.
Got it.
Or people who were living here at one time and now have moved elsewhere and their residence is elsewhere. Because one of the exceptions that they look at is whether that person is residing in the United States for a certain period of time during the last 3 years.
Right.
I think the number is 183 days during the last 3 years would mean that you're no longer, that's one of the exceptions.
Gotcha.
If you've been living in the States during the last 3 years for 183 and then they take the last year, the previous year, and the third year before that, and they do a calculation. That's a little more complicated. I discussed that in my seminar to determine whether or not you qualify for that exemption.
And it's funny because we talked about, when we were talking about topics, when we first launched the show, I said, hey man, we ought to do one on FERPTA, and you were, man, that's like watching paint dry. Let's not do it. But we can give them some tips. Like for example, all right, the burden falls on the buyer.
Right.
So the buyer has to be absolutely sure that the seller is not a foreign national. That starts at the listing appointment because it's something that must be disclosed. The foreign seller must disclose that. And so as real estate agents, our job is to make sure that we're ascertaining all the facts because ultimately the burden falls on the buyer. So what does that mean? That means that the money is not withheld in escrow or at closing from the title company, the buyer's responsible.
The buyer's 100% responsible.
Yeah.
And a lot of people don't realize that, especially real estate agents, they go into a deal and the seller tells them, listen, I'm living in Russia right now,
Yeah.
but I commute back and forth, so I'm not really a foreign national. We don't have to do any kind of withholding or exemption or anything like that because I'm not really a foreign national. Well, you can't. There's no discretion any longer
Right.
for the buyer to say, okay, I'll take your word for it,
No.
because that's led to a lot of litigation. So, and that's why one of the reasons they made the change in the new contract is they no longer give the buyer the discretion to take the seller's word for it, if you will.
Okay.
They need to see a certificate showing that they're non-foreign status, or an application to the IRS for an ITIN number,
Okay.
or they need to make sure that that person, it shows by documentary evidence that they are not that they're not a foreign national. And unless you have that, the buyer really doesn't have a lot of discretion. The buyer has to withhold.
Yeah.
And then beyond that, if the guy says no, but the thing is, I've been in the States for 183 days. I reside here for this period of. Just don't take their word
Right.
for it. You need some documentary evidence, and if there's even an ounce, a scintilla of question in your mind as to whether or not that person's a foreign national, you need to talk to a tax professional or an attorney.
So from the listing perspective, the seller could just from the get-go sign an affidavit stating that they're not, right?
Right.
And that could be just attached, and it could actually even be an attachment into the MLS that puts all minds at ease.
Absolutely.
Okay,
And I, as representing the seller, I always tell the brokers and the agents that I deal with is try to get that affidavit, try to envision what could happen in that transaction if that person lives, outside the United States for any reason.
Right.
Because, in order to avoid that 15% withhold,
Yeah.
sellers will tell you all kinds of stories.
Sure, and then even the delays that it can cause, it can end up, jeopardizing the transaction because of delays while you're trying to work through these
But
issues.
what if you have a short sale? What if you have a short sale and you have a FERPTA issue?
Oh man, I'm gonna get in trouble on this because I'm pretty sure I got this wrong back in the day. Okay? So back in the day, it was my understanding, man, I can't believe I walked right into that.
I opened that up.
You did. All right,
Pandora's
I said, you
box.
know what? I'm gonna stick with my guns. If I'm wrong, I'm wrong. Okay? But how can you have proceeds if it's a short sale? So if you're in a negative situation, there is no seller proceeds. Hence, there should be no FERPTA. Am I right?
No.
Oh, you're kidding me! You were giving me the smile like I was dead on. Man.
I'm telling you, even if it's a short sale, you have to provide those, because there may be a net to the seller. At the end of the day, the bank actually has to take a 15% hit. There has to, if there's any kind of sale. At the time of the sale, there has to be a withhold in the net. But what I usually do is, in order to take care of that, is I usually convince the bank to agree to that, because it could be a lot of money. Technically speaking, what I generally end up doing is I'll have the certificate, or I'll have
the bank can make that a
application.
condition to approving the short sale.
Absolutely.
Yeah, it says we're not going to approve it with another potential 15% hit.
Right.
But dude, man, now the competitive part of me is just driving me nuts. So you're telling me it's a short sale. There is no net whatsoever to the buyer. Hence the whole short sale thing.
You can't mess with the IRS.
I've heard that.
You can't mess with the IRS. They will figure out a way to get their 15%. And at one point, I could make a good argument for what you just said. But the bottom line is the IRS wants their money. And,
I got
and you have to do that withhold. It may later turn out that withhold is not necessary, because the person turned out not to be a foreign national. It turned out not to be, it turned out not to be any kind of net proceeds. But what if that person? Listen, what if that person, if it's a short sale and that person bought the property for a lot less, but they put like another second mortgage on it or something like that, and now they're going to actually net something from the original purchase.
That's why you get paid the big bucks, man.
No, it's the bottom line is you just never mess with the IRS.
Okay.
I never do, and you shouldn't, and no one out there should.
I never have, and nor will I. People are watching this. How about this question?
All right, shoot.
It says here, what if the municipal permit was opened by a previous owner and was not resolved with the current seller bought the property? Well, isn't it back to the same issue that if it's an unresolved permit,
It runs with the property.
it runs with the property, right?
Yeah.
All right. So then this continues here. It says here, now the municipality checks are included. It came up. The city states it is closed. The buyer's title company says it is closed, but it was closed expiring. Okay, I don't think I can understand the question, so I may have to send this to you. I'm gonna try one more time here. It says here, what if the permit was opened by a previous owner and was not resolved when the current seller bought the property? Now the municipality checks and it comes up. Okay, so
Right, so what you have here is one party saying it's closed and one party saying it's open. You have the title company saying, hey, it's closed. According to us, it's closed.
Right.
And then the other party, that's one of the reasons we had litigation on that issue. That's one of the reasons they changed it on the contract, because they want to cast the net a little wider and say, okay, well, we need more information. In order for us to close, we need you to provide all the information regarding that municipal lien.
Okay.
Not just the what you feel but everything that's out there. And again, I mean, what I would recommend, I strongly recommend to people when it comes to any kind of municipal lien issue, is you have the option of not closing, because you may buy and you know what happens with municipal liens. They escalate at greater than 18%. So a municipal lien or a municipal fine that was $100 30 days ago, now you're looking at $500, and then it escalates daily. Some of these municipal fines escalate at $500 a day.
Yeah.
And by the time you realize it, you're looking at a $30,000 fine. And some of these municipalities, guess what? They're hurting for money. I'm in litigation right now with several municipalities because of these fines. My client bought the property. My client acquired the property through a foreclosure process. My client was the lender.
Okay.
Acquired the property through a foreclosure process, and now is having to deal with $60,000 plus in municipal fines. And we're litigating it because we're saying, hey, we bought the property, but those are fines that were submitted at the time that the other owner was there, and we fixed everything. But you know what? It's litigation. And now my client's into this deep over something that could have been resolved way back when.
Gotcha. Okay, I think we're running out of time. One last question. So I want people to understand the term as is, because almost all purchases now, or the vast majority of purchases, they're usually as is contract. So there's a lot of unpermitted work that happens over here. This is South Florida, all right? We know it happens. Just because they didn't take out a permit doesn't mean that there is any action that the city is aware of it. When a buyer is buying a property and they know that there's work that was done there, that no permit was ever obtained, but there's no fines, there's nothing. They're buying it as is. If the city finds out later on and they do something, they cannot go after the previous seller for that. It becomes their monkey, doesn't it?
Right, and we talked about this. You have someone from the city that can be coming into your neighbor's yard to do an inspection, and they see an unpermitted structure in the back of your house. That was unpermitted, built there, but you bought the house with that structure on it, took it as is, and now the representative from the city goes back and says, okay, well, the next thing you find is a notice of violation regarding that unpermitted structure, and guess what? You're required to either tear it down or bring it up to code. It doesn't matter that it was not done with permits, because you're ultimately responsible for correcting the problem.
Yeah, we had a situation on one transaction where it was as is. It went through the inspection process. There was work that was done that was not permitted. The buyer was aware of this, but there were no fines on the property. And then after the inspection period was done, the buyer wanted the seller to go ahead and get all that permitted work, get it all permitted. Seller says, no, I'm selling it as is.
Right.
I told you it was as is. We're past the inspection period. You had a chance to address that earlier. You didn't. You just can't out of the blue decided to come up with that.
Right, it's very easy to check that. I mean, all you got to do is go to the city. If you know that there may be some issues regarding some unpermitted work, all you got to do is go to the city and pull whatever permits have been taken out on that property. If you see that and you'll see the plans there for that property. If that property contains an illegal structure or has, a pool, it doesn't have a pool, and a property you're looking at has a pool, then there's going to be some issues.
Yeah, this buyer knew. It's just that they were upset and they were just trying to use it as trying to put leverage. And it was almost like threatening the seller. Well, I know that this wasn't done, kind of scenario. So
those threats don't work. Sellers in South
sellers
Florida have thicker skin than that.
All right, so listen, we're kind of wrapping up, and again, Omar, we can't thank you enough for all the knowledge, expertise you bring. Go ahead and let our audience know one more time how they can go ahead and contact you.
I'd love to meet with everyone that's looking at us on Facebook right now. If you have any issues, any questions, or want to refer anyone to us that you may know, even for a real estate transaction. I mean, if they want to be represented in the transaction itself, we charge a very moderate fee to just look at the contracts, make sure everything is up to par, make sure that the title is up to par, and give them an expert opinion on whether or not the closing makes sense for them. Give us a call, 954-437-9066, 954-437-9066, or you can email me directly. This is an email that comes to me. It's info@arcialawfirm.com, and I'll promise you guys that I'll make sure to get you the earliest possible appointment possible so we can meet and talk about the case.
Great. And from our perspective, Xtreme Realty Team, we want to help you, your friends, your family, your co-workers, anything that's real estate related. They might be looking to buy, sell, invest, rent. I have professionals standing by right now. Please call us 954-530-0211, 954-530-0211. A message to my fellow real estate professionals: if you're looking for a home, if you need a little bit more support, more training, if there's something about the way Xtreme handles itself that you think might be a good fit, we'd love an opportunity to sit down with you and see if we can do some work together. We also want your help to continue spreading the message, because we're growing it organically. We knew going in that this was going to be a process, and we've made the long-term commitment to continue to do this show and keep bringing you valuable content. So spread the word. Once this is done, it's on our website. Share it. The last one we did, I think we had like almost 4,000 views on it alone. Yeah. And that was all after the fact, people were just sharing it and sharing it and sharing it. So
that's what it's all about. That's what we do this. We want to make sure that the people out there, especially consumers or agents alike, that they're well informed, that they make good decisions, that they contact good professionals. Yeah. Again, that's one of the reasons that I joined the Xtreme team, is because I want to make sure that during the presentations and the seminars that we present to these folks, that they get the very best and most updated information that they possibly can regarding any real estate issue.
Sure, absolutely. And keep sending in your questions. Doesn't matter, the show is done, it's no longer live. I see them. Any questions that pertain to the real estate side, I'll answer them. Anything that pertains to the legal side, I'm going to forward it to Omar to address. So that's the beauty about this format. It's 24/7.
Right.
It doesn't matter, right? And one last time, a great shout out to our friends at New World Title and Denise. And Denise did a wonderful job.
She did a great job. She did a great job.
Stuff.
Absolutely. I mean, I've been working with Denise for like 4.5 years now. And she used to be in my office for a while. Yeah. And let me tell you something. When you talk, we called her Mighty Mouse, because she would just she would take a file and she would just run with it and get it done. Files that we couldn't get closed, she would get it done in a very professional, very timely way.
Yeah. All righty, folks. Well, listen, thank you so much. We'll catch you next week again, Wednesdays, noon to 1 p.m. Thank you.